Good afternoon and welcome to the Environmental Law Institute. You have joined us for the Summer School Series seminar, Law and Policy of Products Regulation. My name is Chandler Randall and I am the Manager of Educational Programs here at the Environmental Law Institute. We are so delighted to welcome everyone to ELI's annual Summer School Series, and I encourage you to join us here at ELI every Tuesday for Summer School. For more information, please see the events page of our website, eli.org. I will note that every summer school seminar will be taking place webinar only this summer to ensure the safety of our panelists, participants, and staff. Thank you for your understanding and for joining us today. At the end of today's panel, we will have time for a Q&A session, so please submit your questions through GoTo's question box, and please do not wait until the end. Send us your questions as soon as you think of them. I would like to also thank our outstanding panelists for joining us today to lend their leadership to summer school. While I will introduce them briefly, the full speaker bios are posted on our website, www.eli.org, and I encourage you to check out their expertise in more detail there. As we begin, I would like to briefly introduce our panel. Lynn Bergeson is the managing partner at Bergeson & Campbell PC and a leading expert on this topic. As the owner of Bergeson & Campbell, Lynn has earned an international reputation for her deep and expansive understanding of the Toxic Substances Control Act, the Federal Insecticide, Fungicide, and Rodenticide Act, the European Union Registration, Evaluation, and Authorization and Restriction of Chemicals, and especially how these regulatory programs pertain to nanotechnology, industrial biotechnology, synthetic biology, and other emerging transformative technologies. Her knowledge of and involvement in the policy process allows her to develop strategies, whether advocating before Congress, the EPA, the FDA, or other governance and standard setting bodies. Also joining us is Rachel Goldstein. Rachel is the Global Packaging Sustainability Senior Manager at Mars Incorporated. She leads a cross-segment packaging sustainability team in Mars's external engagement and key partnerships such as the New Plastics Economy, the Sustainable Packaging Coalition, and the Sustainability Consortium. Rachel leads the implementation of the Mars Sustainability Claims Policy, advising the business on communicating complex sustainability topics to consumers. Lynn and Rachel, we are so glad to have you here with us today. And with that, I would like to warmly turn things over to Lynn to get us started. Thank you.
Thank you, Chandler. I really appreciate that wonderful introduction, very kind introduction. And I thought I was able to move my, oh, there it is. Oh, right. All right, I'm going to do something very, very challenging, which is try to cover the high points on TSCA and FIFRA in 45 minutes or less, because we want to have plenty of time for Rachel's extraordinary presentation and then open it up to a robust Q&A. So, getting a little delay with my, there it goes. Okay. Let's talk first about we're going to talk first about the Toxic Substances Control Act, which regulates industrial chemicals. And I'm going to leave about 10-15 minutes at the end of the presentation to talk about the Federal Insecticide, Fungicide, and Rodenticide Act, which regulates agrochemical and biocidal chemicals. It's important to note that the regulation of products really includes more statutes than just these two key federal ones. In particular, the Federal Hazardous Substances Act is very relevant, or implemented by the Consumer Product Safety Commission, the Consumer Product Safety Act, the Federal Trade Commission Green Guides, the California Safer Consumer Products Regulations statute, and a whole host of state initiatives are equally important. But we're not going to talk about those here in large part because as important as they are not federal. They are state initiatives or not implemented by EPA. Wow, I'm really having a hard time moving the slides. So Chandler, do you think I can get you or one of your colleagues to move them because my cursor is not working?
Yep, happy to do it.
Okay, thank you so much. Let's move to the next slide, please. and one right after that. All right, first we're going to talk about the Industrial Chemical Statute, otherwise known as TSCA. As many of our listeners and viewers know, it was originally passed over 40 years ago in 1976 and continued to be the primary, if not exclusive, industrial chemical federal statute for 4 decades. Many people appreciated that TSCA was deeply, deeply broken. And finally, in 2016, really about 5 or 6 years after a very serious legislative attempt to overhaul the act, the Frank R. Lautenberg Chemical Safety for the 21st Century Act was finally enacted on June 22nd, 2016. Next slide, please. Now, TSCA is intended to be kind of a backfilling statute. As you know, if you have been following other of the ELI summer series, Clean Air, Clean Water, RCRA, Superfund, and other statutes are very much end of pipe. TSCA was intended to provide a very broad chemical safety net. Its very unique focus is only on industrial chemicals, agrochemicals, and biocides we're going to talk about separately. And we're going to spend most of our time talking about the host of new provisions ushered into the Act by the 2016 amendments. Next slide, please. There are a couple of primary purposes of both old TSCA enacted in 1976 and new TSCA updated in 2016. First off, the statute is intended to put information. EPA is very science and data driven, and so the law provides EPA to access both new toxicological and other types of information pertinent to chemical substances and access existing information pertinent to production, import, distribution, and other aspects of chemical management. The law is also intended to regulate chemical substances. So after its production, the law provides EPA with a wide array of tools to address risks that are deemed to be unreasonable, as that term is defined under the law. And finally, one of the core provisions of TSCA that sometimes is overlooked is the Section 2B provision that no regulation can unduly impede or create unnecessary economic barriers to technological innovation. That particular congressional purpose was renewed in the new law and has given rise to some debate regarding how much to regulate a new chemical innovation versus ensuring that it is not, TSCA is not unduly impeding technological innovation. Next slide, please. There are 29 separate provisions in Title I of the law, but we really focus on 7, and they are these provisions here relating to testing, the regulation of new chemicals under Section 5, the regulation of existing chemicals, both with regard to prioritizing their risk evaluation and risk management. Section 8, record keeping and reporting provisions, very important, particularly from an enforcement and compliance perspective for regulated entities. TSCA Section 9, which relates to how does it relate to other federal statutes, particularly occupational safety and health, and RCRA, clean air, and other provisions that has actually invited some considerable discussion of late. The all-important Section 14, how do we protect confidential business information, is intensely competitive, and so there are many provisions with regard to how do we protect confidential information while also allowing the American public and others a right to know what they may be exposed to with regard to chemical products. And finally, Section 26, which is a very broad administration of the Act, which contains many important provisions that are the subject of ongoing rulemakings. Next slide, please. Before we get too far down the road, it's a very important provision to understand what is a chemical substance. Well, for present purposes, a chemical substance here is everything that isn't regulated by some other statute, like FIFRA or the Federal Food, Drug, and Cosmetic Act. So a chemical substance covers an industrial chemical and excludes pesticides, food additives, drugs, cosmetics, and other preparations. It's important to note that a chemical substance is very broadly defined And entities include both the manufacturer of a neat chemical substance and entities that process that substance, which is a broad term under TSCA, meaning preparing it, handling it, blending it, or otherwise manipulating a chemical substance for purposes of downstream formulation or inclusion in another product. Importantly, manufacturer includes an importer. So if you think, oh, good, we'll just manufacture the substance overseas and then bring it in. Nope. The minute that substance hits the territory of the United States, you are considered a manufacturer and subject to all of the provisions pertinent to manufacturers. An important distinction under TSCA is the difference between a new chemical substance and an existing chemical substance. A new chemical substance is any substance that is not included on the TSCA inventory, which is a long list of chemical substances that have been acknowledged by EPA, not necessarily reviewed by EPA, but acknowledged for purposes of its reporting on the inventory, which dates back to the late 1970s. A new chemical substance is a chemical that is not listed on that inventory and is thus subject to pre-market review approval by EPA. Presently, there are about 86,000 chemicals listed on the inventory, but only about 44,000 of those are considered active. And that's a consequence of the inventory reset occasioned by the 2016 amendments. Next slide, please. Now, the 2016 amendments ushered into the law many provisions, but only 7 of them are we going to consider very quickly here. First off, a major change from the prior law is a mandatory duty by EPA to evaluate existing chemical substances with clear and enforceable deadlines. One of the major failings of the old law was once a chemical was considered existing, there were very few opportunities for EPA to regulate exposure opportunities that might have invited an unreasonable risk determination. So there was no duty to review under the old law. So the writers of the new law made darn sure that there would be mandatory duties and enforceable deadlines against which those duties would be implemented. Chemicals are now assessed against a risk-based safety standard with no consideration of non-risk factors. Old TSCA, of course, had a risk-benefit balancing provision that gave rise to considerable judicial and logistical and implementation challenges by EPA. So that went away. The unreasonable risks are identified in the risk evaluation must be eliminated. Again, under old TSCA was an elegant and carefully considered law, but really lacked any enforceable mandate. So under the new law, once an unreasonable risk is identified by EPA, EPA has a duty and an obligation to eliminate that risk through the imposition of a broad range of risk evaluation and risk management tools available to it under the law. EPA also has expanded authority under the new law to compel the development of chemical information when needed to do so by either order, rule, or consent agreement. This is an important new tool that EPA has. And under old TSCA, EPA was required to engage in a quite lengthy and laborious rulemaking. So EPA now has order authority, which it has begun to implement. Next slide, please. Under the new law, EPA is required to make an affirmative determination on new chemicals. This is a huge change under the new law, which caught a lot of us by surprise. Under old TSCA, once a pre-manufacturer notification was submitted and 90 days went by, the chemicals submitter was authorized to begin commercial production once it was added to the inventory. Under the new law, EPA now is required to make an affirmative determination with regard to whether the chemical poses an unreasonable risk, EPA lacks sufficient information to make that determination, or EPA makes an affirmative determination of no risk. So that's a huge change that has also given rise to some considerable debate over the new law. With regard to the substantiation of confidential business information, under the old law, there was no statutory substantiation requirement for CBI claims. That is considerably revised now under the new law, and it's harder now to assert a CBI claim. It must be corroborated up front. which requires some thought on the part of the person making the claim, and to do so consistently and to ensure that a chemical is not revealed in another context. And in our social media society, it's very important to make sure that that internal policy is coherent and well thought through. And it's considerably harder today to assert and maintain confidential business information, but the duty or the ability to make that claim still exists. EPA also has new funding sources, which means that entities availing themselves of TSCA, whether a new chemical under Section 5 or risk evaluation under Section 6, or an assertion of confidential business information under Section 14, EPA is now authorized to assess considerably higher fees for up to $25 million of the cost of EPA's implementation of those provisions. So the old law capped fees a specific amount. The new law is considerably more generous to EPA. Next slide, please. All right, let's talk a little bit about information gathering very quickly. EPA has considerable authority under TSCA Section 8 to require chemical manufacturers, importers, and in some instances, processors to submit information to EPA. As noted, EPA is very, very, very data-driven, and the better the quality of the information and the amount of information has, the better able it is to target its limited resources to addressing chemicals that pose the greatest risk. So under Section 8, EPA can compel lots of information and does so every 4 years through the occasion of the Chemical Data Reporting Rule, which requires, as noted on the slide here, manufacturers of chemicals over 25,000 pounds that are listed on the TSCA inventory to report certain information with regard to chemical use, exposure, and related information. The new reporting requirement that began June the 1st of this year, and the reporting period closes November 30th. This is part of that quadrennial reporting obligation that gives EPA lots and lots of information about chemicals that might be exposing people to potential risk, and enables the agency to make informed judgments about how best to regulate those chemicals. Next slide, please. I'm going to why don't you slip down to the next one, because this chart provides a good overview on the next slide, please, of information collection of existing chemicals. EPA has broad authority under TSCA Section 8A, C, B, and E to collect information in each of the categories noted. I'm not going to go into a lot of detail because we don't have time, but just recognize that EPA has very, very broad authority to compel the production of information relating to chemical use, toxicological information, information regarding allegations of adverse effects. EPA is required to, or is authorized to compel the production of these so-called 8C allegations. EPA can compel the production of existing information on toxicological studies under 8D, and EPA is also and very cognizant of its authority under 8E, which compels companies immediately to report substantial risk information to EPA, so-called 8E adverse risk information. So with these tools in hand, EPA is able to gather quite a lot of information about the chemicals that might pose risks in a way that warrant more immediate EPA attention. Next slide, please. Now, Section 8 provides a lot of tools for EPA to gather information. Another important opportunity is for EPA to analyze that information, and if it determines that it thinks there's a problem, it can then use its Section 4 authority to issue administrative orders or engage in rulemaking or negotiate a consent agreement to require entities that produce or import those chemicals to develop new information to help round out what it might have determined with regard to an assessment of the existing information gathered under TSCA Section 8A. So next slide, please. So TSCA as noted in my intro remarks, gave EPA a new order authority to compel the development of toxicological or other information by way of order. EPA has just now begun to explore the parameters of its authority under TSCA Section 4, and it did compel testing with regard to PV29 either earlier this year or late last year. And I would expect in the years to come, EPA will be deploying its new order authority probably more routinely. EPA has been distracted given all of the other things it's been doing to implement TSCA, but I think we can see down the road the opportunities for additional testing authority under TSCA Section 4. Under Section 4H, EPA is also urged to reduce or replace testing on vertebrate animals, which is a good thing. So alternative testing strategies and alternative test methods are now being evolving at a very fast pace to address this congressional expression of interest in averting vertebrate testing. Next slide, please. So you've got the 8A authority that EPA has supplemented by its new authority under Section 4, and that gives EPA evaluating chemicals under Section 6, which is risk evaluation authorization. So we're going to turn to the next slide and review EPA's authority under TSCA Section 6. EPA, first off, is required, and as noted at the beginning, under old TSCA, EPA had authority to review unreasonable risks identified with existing chemicals, but there was no infrastructure to do so. So what new TSCA did is require EPA to prioritize chemicals for risk evaluation, and then to establish a process for actually undertaking the risk evaluation. So under the new law, EPA was required to establish a risk-based process to identify high and low priority substances. High priority chemicals are those chemicals that may present an unreasonable risk to injury to human health or the environment. And low priority chemicals are defined to include those chemicals that don't meet the standard for high priority. EPA issued a rule in June of 2017 by order of the statute, 1 year from the date of implementation of the new law. And it has been working under that prioritization scheme for the last 3 years. Next slide, please. Under the law, EPA was required to identify an initial set of 10 chemicals that was drawn from a pre-established work plan chemical assessment list that EPA had prepared under the Obama administration. EPA is required to release the scope, it's called a scoping document, of these first 10 in June of 2017. It was then required a year later to issue something called a problem formulation document, which helps identify how best to identify the chemical use patterns that could give rise to unreasonable risk. EPA then began drafting the risk evaluations back in the 2017-2018 timeframe. And to date, EPA has issued 10 preliminary risk evaluations and 1 final risk evaluation for methylene chloride, and is slowly getting out the remaining 9 chemical risk evaluations by the end of this calendar year. Next slide, please. In various public venues, EPA has indicated that it probably will not hit the 10 final risk evaluations in 2020. There are a number of complicating factors that has delayed EPA's ability to meet that deadline. But so far, EPA has hit every deadline required of it under the new law. The risk evaluation process, however, has proven to be difficult. And not surprisingly, EPA is hoping to really hone its risk evaluation processes on these first 10. So the other risk evaluations that follow will be all the better for it. EPA was also required, and did so timely by December 20th, 2019, of identifying a final list of 20 high priority chemical substances. And it's those 20 that EPA is also working on a scoping document. EPA issued the scoping document earlier this year, and the next 20 risk evaluations will soon be underway when a final scoping document is established for each of the 20 new high priority chemical substances. Next slide, please. The process, as you can see, is very formulaic. EPA is required to prioritize and then draw down the 10 high priority substances, conduct those risk evaluations, identify an additional 20 high priority risk evaluations, and as the risk evaluations are completed, EPA is required to identify another chemical substance to conduct a risk evaluations. This is a process that will go on for decades. With regard to the safety standard, chemicals are evaluated against a new risk safety standard to determine whether a chemical poses an unreasonable risk. And importantly, and as noted before, EPA makes this determination without any consideration of costs or non-risk factors. This is a huge change from old TSCA. And importantly, risk to susceptible or highly exposed subpopulations must be considered. That's a new aspect of the law. EPA can take and will take risk management action on any unreasonable risk, and cost and available alternatives can be considered at that phase of the risk evaluation process, but in determining whether an unreasonable risk exists, there is no such opportunity to consider cost or non-risk factors at that stage of the game. Next slide, please. What you see here is just a schematic borrowed from EPA with regard to the process for identifying and issuing final risk evaluations. So it is very formulaic and very logical, and I think Congress did a great job of establishing a process that EPA can adhere to process thousands and thousands of chemicals and evaluate their risk, and then issue risk management rules mitigating those risks. Next slide, please. Just wanted to identify a couple of provisions relating to the new law. Persistent bioaccumulative and toxic chemicals have a separate regulatory regime, and importantly, no risk evaluation step is needed for PBT chemicals. They're thought to be in a class unto themselves. Next slide, please. Also, as noted at the beginning, the TSCA inventory has been reset. That means EPA tried to take a look at the 86,000 chemicals that were on the inventory to determine which of those chemicals are actually in use today and are active as opposed to inactive. So the final inventory notification was issued back in August 2017, and we now know that there are about 44,000 plus, give or take, active chemical substances. And if your chemical is on that list, you are good to go. If it's not on that list and not otherwise exempt from TSCA regulation, you have to submit a pre-manufacturer notification under TSCA Section 5. Next slide, please. Let's talk just a real little bit about the new chemical review process, because we spend an awful lot of time at Bergeson and Campbell reviewing new chemical applications. I think the important thing is to recognize that EPA has a very well-oiled machine, as it were, for reviewing new chemicals. Although there is no minimum data set required with respect to a new chemical notification, EPA conducts a very extensive review. Next slide, please, with regard to categories of information, and also relies upon a number of models for predictive purposes, both with regard to chemical releases and exposures and toxicological reviews. So even though a lot of information is not mandatory for purposes of a pre-market notification, EPA has a very well and very sophisticated system for predictive methods to determine whether a new chemical substance might. I think you can probably go to the next slide, beginning with significant new uses. EPA, if it determines that a new chemical poses an unreasonable risk, EPA is required under the law to identify how that risk might be mitigated or regulated. And it does throw through the occasion of a significant new use rule. And there's an awful lot that we have on our website and in many of our postings on how EPA goes about determining what is an unreasonable risk, what is a foreseeable risk. I'm not going to go through that now, but recognize that the agency has a lot of experience in developing, through its application of predictive methodologies, what might pose an unreasonable risk and how best to address that risk. Some of the measures that EPA does so is to impose personal protective clothing and equipment restrictions on new chemical development. It might require that a chemical not be subject to any type of release in the production process or manufacturing process. So there are lots and lots of tools EPA uses to abate potential risk posed by new chemicals. And similar to what we talked about before, there are determinations that EPA makes with any new chemical. First, if a chemical is thought to present an unreasonable risk, most entities that have that determination made by EPA will probably withdraw the PMN. With regard to available information, if EPA determines there's insufficient information with respect to a new chemical, EPA might require additional information or impose conditions that will mitigate or substitute for the inability to assess a particular aspect of a new chemical. And the determination everybody likes to get is a not likely to present an unreasonable risk, in which case the chemical is considered dropped from review and might not even take 90 days to get there. And the minute EPA makes a not likely to present determination, you're good to go and can immediately commercialize your chemical. Next slide, please. Next slide, please. I'm going to go quickly through these because I'm running out of time. All right, there are lots and lots of very, very interesting TSCA implementation issues. Not surprisingly, there have been a number of lawsuits filed by stakeholders on both sides, both for and against EPA. We have all kinds of information on all of the ongoing litigations with respect to EPA's risk prioritization and risk assessment process. What is out of scope for purposes of new chemical and existing chemical review. So lots going on there. The new chemical review process has been the subject of considerable discussion. In addition, not the least of which is because how EPA determines what is a foreseeable risk, what is considered a condition of use that is foreseeable. These are all issues EPA was forced to address immediately because there was no phase-in period for new TSCA at all. So the minute the law was signed into law on June 22nd, 2016, EPA had to immediately apply the new provisions, which has given rise to a lot of consternation, but EPA is doing really well and has addressed many of these issues in a way that I think chemical innovation is progressing. And it's not perfect, but we're getting there. Alternative testing strategies as a consequence of the 4H provisions are moving along, but what is an appropriate new testing method, what can be reliably implemented and used consistently, these are all very difficult determinations that take time and effort, but that's moving along. The risk evaluation process has been the subject of considerable debate and is evolving. As noted, we should have probably 8 or 9, give or take, final risk evaluations by the end of this calendar year, more in 2021. But this process is very iterative. And as the agency expands its experiential database and as industry understands and participates in that process, the process will continue to evolve and progress. There are a host of operational challenges for EPA, not the least of which is just staffing, money. When you have a brand new law like this imposed upon the agency, it requires many more people, many more experts in various areas of chemical risk. COVID didn't help matters. Dispatching everybody to work from home has been an additional strain on EPA, but it has really done a beautiful job in transitioning to a remote work environment. The implementation of the new fees rule, the EPA issued a fees rule in October of 2018, and is now beginning to determine who will be paying fees for the EPA initiated risk evaluations. That's been a huge deal. And because the fee for an EPA risk evaluation is $1.35 million, identifying who is on the hook to pay for that has been a formidable logistical and operational challenge. So EPA has been working through that with industry, and we should be seeing much more on that down the road. With regard to institutional capacity, EPA does a very good job of attracting the best and brightest scientists, and they've done, I think, a very good job in implementing the new law with respect to TSCA Section 5 new chemicals and TSCA Section 6 existing chemicals. But the agency is always looking for good qualified people to help with this institutional capacity issue. And I think if Assistant Administrator Dunn were giving this presentation, she would urge people to consider careers at EPA, recognizing that it's a rewarding job and a very essential one. Congressional oversight has been, not an issue. I think the House and Senate have had a number of hearings over the past 4 years on, are we getting it right? Did EPA get it right? But that's an iterative process, and congressional oversight will continue. That will be especially interesting with our elections coming up in November. So let's spend the next couple of minutes on FIFRA, which is the companion federal, next slide please, federal law. I'm not going to spend as much time. I have about 13 slides on this, which I'm literally going to breeze through, recognizing that it's a very old statute and a very arcane one, and not a lot of people work in this area, but it is a fascinating intersection of law, science policy, and regulation. And next slide, please. We'll spend a little bit of time just talking about the program. EPA, of course, implements FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act. The Office of Pesticide Programs is the office that coordinates the interactions between and among all of these different divisions, because there are many different types of pesticides. You all probably think of a pesticide as something you spray to, get bugs off of you in the summertime, or keep your barn free of rodents. But there are lots and lots of different pesticides and lots of different aspects to their regulation, which the work is actually done by these various and highly specialized offices at the EPA. Next slide, please. It's also important to recognize that FIFRA really is intended to pretty much preempt the field of chemical regulation with respect to agrochemical and biocides. But there are a number of states that have authority and have developed pretty robust state regulatory programs. So where a state has a federally approved pesticide program, the state has the primary enforcement authority. But as a practical matter, there are only a handful of states that have really developed separate state programs that are pretty mature and also pose considerable market entry challenge for pesticide producers. And those include California, New York, Florida, Wisconsin, and a handful of others. So it's important to note that if you're counseling companies, you've got the federal requirement to get a state or a federal pesticide registration approved, but in every state where that pesticide is applied, you are required to register it in the state, which in about 46 instances out of the 50 states is a relatively ministerial task of just getting your label approved for a fee every year. But in California, New York, Florida, and several other emerging states, there are relatively mature state programs that also require time and money to administer and get approved if you are going into market. Okay, next slide, please. What is a pesticide? Well, in short, it is any substance or mixture of substances intended to prevent, destroy, repel, or mitigate any pests, very broadly defined. It's very important, too, to note that a substance is considered by EPA or state regulatory bodies when it's intended for a pesticidal purpose requiring registration. So, in other words, if a person who distributes, sells, or manufactures a chemical substance and it claims, states, or implies that the substance has a pesticidal potency or is to be used as a pesticide, it's considered a pesticide, which has caught some people by surprise because most people think, well, you have to have a pesticidal potency, and if you're not exercising that potency or don't intend to, you're out of the realm of a pesticide and beyond FIFRA jurisdiction. And it's a little more complicated than that because of the claim states or implies the substance has a pesticidal potency. Next slide, please. There are lots of different types of pesticides. There is the active ingredient, which is the small amount of the neat chemical that actually provides the pesticidal potency to prevent, destroy, repel, or mitigate a pest. Then there are inert ingredients, the everything else in a pesticide formulation, and inert, I would agree, tends to be a somewhat misleading term because they do have activity associated with those chemicals, but not a biological activity that the active ingredient does. So a pesticide formulation consists of an active and a bunch of inerts. There are various types of pesticides, the so-called conventionals, which we tend to think of the products that are used on raw agricultural commodities, like glyphosate, Roundup, or some of those category of older conventional pesticides. There are so-called minimum risk pesticides, which is a relatively newer category of chemicals that are subject to diminished regulatory requirement. Biopesticides, which are chemicals derived from natural ingredients or minerals, considering plants, animals, and bacteria. Antimicrobial substances, which are very popular today because of COVID and other endpoints to which antimicrobials and biocides are applied, and so-called treated articles. Next slide, please. I'm going to go through these next several requirements very, very quickly. Similar to TSCA, new chemicals under FIFRA are subject to pre-market approval, but not similar to TSCA. FIFRA has always required a biological ingredient in a chemical formulation subject to jurisdiction under FIFRA to be subject to pre-market approval, which means that everything subject to review in the formulation is tested against an unreasonable risk standard for non-food uses and a reasonable certainty of no harm standard for food uses. And every aspect of the chemical is subject to this standard, both the active ingredient, the biological component of a FIFRA product, and the inert formulation. So unlike TSCA, FIFRA is a use specific, not a chemical specific. So under FIFRA, every use to which a pesticide is put is subject to review and regulation under FIFRA. Next slide, please. There's a very detailed regulatory framework that has been in place for literally decades. Every single chemical in a pesticide formulation is subject to data requirements. There's lots and lots and lots of testing associated with chemical review under FIFRA. New active ingredients take many years, anywhere from 3 to 6 years for review and approval by EPA, usually at a cost of millions of dollars of data, because both the neat chemical itself must be evaluated against guideline standards by EPA, and each of the uses to which the chemical is put is subject to review. Next slide, please. Similar to TSCA, the regulatory framework pertinent to agrochemicals allows for trade secret and confidential business information protection. EPA has adopted a relatively narrow range of protected information to enhance transparency and address right-to-know considerations. And there's a whole different provision under FIFRA, Section 3, called data compensation, which allows parties to rely upon some other entity's data to support their own proprietary product formulation after a period of years that a chemical has been in commercial operation. These so-called data compensation provisions allow for third-party use of proprietary data, both to accelerate entrance into the marketplace and also to avoid the duplication of data in ways that Congress believed would be unproductive and an unnecessary strain on animal and other types of toxicological testing. Next slide, please. This is just a screenshot of a standard label. We often say in FIFRA, the label is the law. Every single provision in this label is carefully curated and crafted by EPA and the entity seeking registration, ingredient disclosure, approved claims, use directions. All of this stuff is carefully in a negotiation between EPA and the pesticide registrant. So nothing in that label is incidental or unnecessary. And obviously, users of chemicals are urged to review the label carefully to ensure it's being used as intended. Why don't you skip through the next couple of slides and we'll go to, just go to the next one. EPA has made a concerted effort over the years to really promote safer or so-called reduced risk pesticides. There are incentives to going this route, reduced fees, expedited reviews, dedicated resources. So there are just an enormous divergence of regulatory types of pesticides, but just recognize that EPA has done a very good job of promoting safer or reduced risk pesticides with a view toward incentivizing their use and substituting these chemicals for chemicals that are thought to be older and perhaps more toxic. Next slide, please. The enforcement framework is very mature under FIFRA and very active, I might add. EPA has enormous authority to reduce sales, to stop sales through the use of so-called stop sale use and removal orders, or SUROs. EPA is authorized to impose significant civil and criminal penalties under FIFRA. EPA has been very energetic in its response to COVID-19, and I would urge you to take a look at our pest blog. If you have any doubt about EPA's commitment to ensuring that chemicals that are not authorized to be used against COVID are apprehended at the border or subject to SURO orders, because the agency's enforcement has been very robust over the past 6 months. It has always been, but the agency has made a special effort to ensure that the American public is protected against unlawful or unsubstantiated COVID claims. Just a final thought, I'm going to spend 30 seconds on the next slide, which is current FIFRA issues. Lots going on for those of you that are looking for a career in FIFRA. I just noted COVID-19 enforcement issues, pollinator issues, whether or not chemicals have contributed to diminished bee colonies is an area of hot debate. Prop 65, the interface between requiring cancer warnings and FIFRA, is an area of considerable interest and has been for years. There was a recent case in the Eastern District of California just on June 22nd. If any of you are interested in the interface between Prop 65, First Amendment rights, and FIFRA preemption provisions. Some of the same issues we talked about with regard to evolving technologies and EPA's institutional literacy and capacity are front and center in FIFRA as well, because these are both very data-driven, highly scientific statutes, and EPA is always challenged to ensure that it has the appropriate staffing and institutional capacity to address the issues that are emerging under FIFRA. So with that, you can move to the next slide, only because I want to point our participants to our TSCA blog and our FIFRA blog. We report on information many times each week, and anything I mentioned here is reported on our blog, and I would urge you to take a peek. And with that, I'm going to cede the microphone to Rachel.
Thank you so much, Lynn. Just a reminder to our participants to keep sending in your great questions, and I will hand things over to Rachel. Thank you.
Hey, great. Thank you, everyone. Good afternoon. It is my great pleasure to be here with you, of course, virtually. And I want to thank the Environmental Law Institute for inviting me to be here to talk to you about one of my favorite topics, which is packaging sustainability. I also like to thank Lynn for improving my knowledge of TSCA and FIFRA. It was not an area that I worked on while I was my time at EPA. And so today I'm going to talk, let's see, let's move slides. Did we? Okay. So for today, I want to talk about packaging sustainability. It'll be a bit of a different view, as this is a space that doesn't quite have the same level of regulatory framework that TSCA and FIFRA have. And today I'm going to cover a number of different topics, just to give a flavor of the complexity of the issue, as well as the myriad number of activities that are happening in the space. For those of you who may not be familiar with Mars, just briefly, we're family owned and privately held. We have a diverse portfolio, but I think many familiar brands such as M&M's or Snickers and Twix. For those of you who are spending more time with your pets these days, we're also a large pet care company. We also have Mars Food and Mars Edge. We're 125,000 associates around the world, and I mentioned the diverse portfolio that we have in part because it sets us up for talking about packaging sustainability, because with all those different products, we also have a lot of different packaging needs. Okay, so also to frame the conversation a little around the broad sustainability program at Mars. In 2017, we launched our Sustainable in a Generation plan, and it's a set of 3 interconnected ambitions that we think are necessary for business to be sustainable into the future. So there's the Healthy Planet pillar, which is our environmental impacts, Thriving People, which centers more around the social impacts, and then Nourishing Well-being that looks at food safety and product renovation. And today when we talk about packaging, our circular packaging plans fall under our Healthy Planet pillar. So, you know, what are we doing about packaging sustainability? Well, we know we know that there are a number of things that we need to do to make packaging more sustainable and meet the circular packaging plan that we have. And it's really based around removing unnecessary packaging, redesigning the packaging that we use for circularity, investing to close the loop, you know, anything from supporting EPR and use of recycled content. And then we have some anchor goals around 100% recyclable, reusable, or compostable for our plastic packaging, as well as a reduction of virgin plastic use. Okay, so let's talk a little bit, let's go big picture and talk about the why, and why packaging and plastic in particular is very much has a lot of focus on it. So what we know is that there's no shortage of images out there around plastic in the environment. Plastic is litter in the rivers and in the oceans. But in addition to the visuals that we see, there's also a growing body of science. And that started with the pivotal GEMBEC study that was published in Science in 2015. And that study is something that really started to change the external conversation. What that research did is it put numbers and causes into something that we knew was intuitively happening around plastic litter. She was able to talk about how much plastic is entering the oceans, as well as the cause of poor or mismanaged waste on land. And from that, we see additional science continuing to evolve, but we also see things around how much of the ocean plastic is really related to 10 rivers in terms of things starting from terrestrial waste to being in the rivers and eventually flowing into the ocean. And for some of you on the line, I think this is something that might be familiar to you in terms of a waste hierarchy. And traditionally, landfill, and particularly landfill that does not have energy capture, has been the bottom of the hierarchy. And I think what we start to see around the science here with marine plastics is that the ocean, unfortunately, is becoming somewhat by default the new bottom of that hierarchy. But the top of the hierarchy remains the same, right? So we're looking at how do we reduce packaging, plastic or otherwise, as the first line of sustainability, that we don't have to manage materials if we don't produce them in the first place. And then secondly is still reuse, and that is where we, if you think of almost the old milkman model, and how do you reuse packaging rather than have it be disposable. And that is the preferred inner loop when we talk about the circular economy, and then we have recycling. But all of these are strategies to manage materials that are put into the marketplace and into. So let's talk a little bit more about packaging. We know that packaging plays many important roles, right? And while packaging waste is a visible reminder of waste management challenges, that packaging still matters, right? There's a reason we use it. It is something that helps companies get their product from their factories to distribution centers, to retailers, to consumers, all safely, so that food quality is preserved, or whatever the material or product is, that it is transported safely through the process. And packaging for us certainly helps ensure compliance with market and food safety standards. So you can see here some examples of protection of the ingredients and products, minimizing food waste, which is also a key environmental impact area, preserving freshness, providing nutritional information to consumers. And while we can all agree that packaging doesn't belong in nature, it doesn't belong on the ground, in the rivers, or in the oceans, and that what we all strive to do is to keep materials, plastic or otherwise, at its highest value as part of a circular economy. So some of the challenges with today's packaging, right? So, companies use packaging of many different types of materials. So we're looking at things of sturdy cardboard boxes for shipping, and I'm sure plenty of us have been probably ordering things online a little more than we might otherwise, and we see those cardboard boxes. There's also lightweight paper, metal cans, glass jars, and a variety of different plastic materials, whether rigid plastic, flexible, or multi-materials that might be laminated, where plastic is laminated to metals and or paper. And for some of these materials, particularly metal, paper, and rigid plastics, they're frequently recycled. Where that infrastructure exists, and in some more informal recycling markets, there are still opportunities for that material to get recycled. Flexible plastics are lightweight and can have a low carbon footprint. They use significantly less material to get the job done. If you think back to the waste hierarchy in terms of reducing the overall material used, but they're recycled at a far less rate, and in some cases, not at all. And then not just, when we think about also recycling or keeping those materials in play, that there are challenges in developed markets where even where we have waste collection, you can have still low recycling rates because there aren't end markets, or it's hard to sort and separate those materials. And in developing markets where there's no collection, there's definitely low recycling and potentially higher leakage into nature. And we also know that plastics in use today are made from fossil fuels, which can be considered a finite resource. So why is collecting and recycling of plastic packaging such a challenge? And in some cases, this challenge can also be transferred to materials or pack formats that are small and lightweight. But they can be hard to collect and identify. And the less weight, while again helpful from a material reduction standpoint, translates often into low market value. And economics of recycling are not always viable because of that. And what we find is that there's this tension between material efficiency at the start of life and material value at end of life. So it's, we've maximized, or we've made it so efficient and we've lowered the carbon footprint upstream, but that same engineering makes it difficult to get value of it downstream, and we need to find a way to close that gap. So in this slide, I'm going to spend a little time to actually just kind of going through what happens with packaging and how does it actually have value through the system. What we see in the upper right is a Sankey diagram from the new plastics economy, talking a little bit about the fate of all plastics, right? That very little of it actually does get recycled. Things get landfilled, incinerated, or leaked. But there's a challenge in bringing those recycling numbers up. So thinking about what happens once a consumer is enjoyed or used the product that the packaging is protecting. So I'm going to go with the right side of this flow chart first. So does it enter a managed waste system? If the answer is yes, then is it separated by a consumer? So many of us in the US can go ahead and put things into a separate recycling bin in our homes and it gets picked up, right? So if it's separated by the consumer, then it has a higher chance to get recycled. If the answer is no, then it's likely to go to landfill or incineration, depending on the local market conditions. If it is separated by the consumer, then is it valuable to a material recovery facility? So, and that will depend on where you are in the world, the value and weight of the material in terms of commodity prices. So if it's not valuable to the material recovery facility, it'll get landfilled or incinerated. If it is, then it can get recycled. But if you're in markets that don't have a managed waste system, right? So does it enter that system? If it doesn't, then it can get littered going onto the ground, into rivers and oceans. Is it valuable to a waste picker or the informal economy? If the answer is yes, then it can get recycled. If the answer is no, then it still may end up as litter or in the rivers or in the ocean. So there's a lot of steps in terms of whether or not something really does get recycled in practice. And then when we think about things getting recycled, there are a number of different technologies that are out there. Traditionally, most of our materials get recycled through a mechanical recycling process. And this is what you see in the middle of the slide. And that's where plastic ultimately being separated out gets shredded into smaller pieces that ultimately go back into pellets and into new materials, whether it's building materials, other packaging, textiles. But there's a lot of things that don't make it through the system of mechanical recycling to get another use. There's a whole family of other technologies that are either under the terms chemical recycling, advanced or enhanced recycling, where you go beyond just shredding the materials, but actually bringing it back down to more of a monomer state and going back to feedstock to create essentially the virgin equivalent plastic packaging or plastic materials. And those technologies, while not new, are getting sort of a better look again in terms of whether or not it can handle materials that don't do well in mechanical recycling, but also have the potential to produce an output that is safe for food contact when we think about primary packaging. There are other outputs from that process where we see as fuel and energy, and while it is an output of the process that's considered recovering of materials, there are a number of definitions of recycling where fuel and energy are not considered recycling. So whether it's ISO, whether it's EPA, whether it's the new plastics economy. So if it's going outside of that loop to monomers, then it's a recovery of the material, but not necessarily considered recycling. Okay, so I'm going to switch gears here a little bit in terms of, okay, now that we know some of this, what are some of the ideas and out there about how we start solving some of these challenges, right? And so this is a graphic from the New Plastics Economy work in 2017, talking about strategies to transform the global plastic packaging market, right? And so there are three areas where part of this is recycling today with radically improved economics and quality. There are things that can be recycled today and just do a better job of it, right? So if you think of a PET beverage bottle, and the same thing with metals and paper, there are things that we can recycle today that don't have the rates that we'd like it to have. And so can we do a better job of that? But we also look at 20% of the market. Are there things that we can put in reuse models? So again, sort of if you think of the old milkman model, what package can be taken back, cleaned, refilled, sent back to the consumer in a reuse model. And then there's a portion that just needs fundamental redesign and innovation according to the new plastics economy, right? And that's when we think about things upstream. Can we eliminate things that we don't need? Can we redesign materials for different barrier properties? Can we look at the product a little differently? And I'll talk a little bit more about that in the next couple slides. It's some interesting examples that we see out in the world. So again, this fundamental redesign, this is going to be the upstream work. And one option for that kind of redesign is reducing fossil-based plastics, right? And there are a few options here that we've seen companies experiment with. So one option is whether or not you can do bio-based, biodegradable, or compostable materials. You see that for the pouches on the right. You can look at moving to other materials such as paper, metal, or glass. You see the water bottles in metal bottles here instead of plastic bottles. And then for the Coca-Cola example in the middle, you see instead of the 4 or 6 pack plastic rings, that paper is being used to hold those hold the soda bottles together. And these are not easy decisions to make necessarily. There's a lot of trade-offs and things that companies, as they start to evaluate their packaging choices, need to be aware of. So for example, do you have the right infrastructure? Compostable or degradable materials need a certain set of conditions for full degradation to either to degrade into their components or go into compost. And if materials go into a landfill, those are not the conditions that really foster that kind of degradation. When we look at replacing plastic with paper, in this case, we would want to ensure something of sustainably sourced paper. You do use more material in terms of just the strength of the materials in this example, and also with metals, looking at the full life cycle analysis, right? If upstream metal tends to be quite carbon intensive from energy use, but if you use a lot of recycled content material in metal, you lower that footprint. So there's a number of different complexities and trade-offs that all packaging designers need to consider when making these choices. And then we see something around fundamental redesign of a different sort. So here we've got things where you can fit cans together where you don't necessarily, it's redesigning of the can to fit them together so you don't have another material that you need to hold them together. And then the example on the right is actually a redesign of the product itself. So we think about toothpaste that we use every day. These are toothpaste tablets, right? And so instead of a paste that goes into a tube that is challenging to recycle, we have companies who are looking at redesigning toothpaste into tablets that can go into a more recyclable container, whether it's glass or plastic. So that's again an example of this kind of fundamental redesign. We also see more startups and pilots around reuse and refill of materials. And again, the New Plastics Economy has a publicly available guidebook for those who are interested in that kind of landscape assessment of reuse opportunities and companies who are providing those. And again, we have 2 examples here in terms of bulk refill. I think many of us have probably seen things like that in our supermarkets, or at least pre-COVID, where we may have used our own recycled, reusable coffee mugs at our favorite coffee shop. Again, those tend to be on a little bit of pause at the moment. But you see here, meanwhile, doing something of similar around the dispensing at a supermarket, but also being able to use RFID codes to manage data along with that. The other example on the slide of Happy Circle is really trying to give an alternative in developing markets to single-use sachets, right? And finding a way just for people to be able to purchase the amount that they need and they can afford, but not necessarily in a disposable container. Another example of that is a company called Algramo, who have started in Chile. And again, where you can bring in essentially any size dispensing container, but use as much or as little as you need or can afford at any given time. Again, another opportunity that is looking to replace single-use sachets. And then again, another example around recycling and adding value to end of life. As I mentioned before, what drives some of the recycling and the economics of is how valuable is the material that is getting collected, whether through a formal or informal recycling economy. And there's a group called Plastic Bank that has started something called social plastic in a couple of different developing markets, really providing incentive for people to collect materials so that they can be reused into other materials, right? And so what we have examples here of Henkel using shower gel bottles made from plastic that came through Plastic Bank, and then Marks and Spencer using that same plastic as well to make shopping bags. So again, trying to find some value and developing the end markets that keep materials out of oceans and off the ground, but actually into productive use. And one other example of plastic waste going into durable goods, where we see in Ivory Coast, essentially the plastic is going into building blocks that go into building schools. And there's the opportunity for some more durable goods where plastic waste can go as well. Okay, so in my group of topics today, I'm going to switch again to recycled content. And that's something that really helps to stimulate demand for what gets recycled, right? So one of the things about recyclability is that you need an end market, you need someone to take the materials, otherwise it doesn't get recycled in practice. And so what we see in terms of recycled content, Mars is one of many companies who has a commitment around recycled content. Ours is for 30% by 2025. And that really for all the different companies out there who have commitments, that if you take a look at, if you add that all up today versus what's being produced today, that there is a bit of a gap, and we know that some new supply chains need to be built to meet those commitments across the board. But we know the supply is somewhat challenged, and that's even before COVID, right? So this is something where in 2018, the China national sword, so China became declined to accept imports of plastic waste from other countries, and they had very stringent quality requirements that pretty much most countries couldn't meet, and that sent shockwaves through recycling markets around the world. So we had some disruptions there in terms of those supply chains, and then there was lack of infrastructure to process them in market, and that's starting to change as countries start to look to invest in recycling systems in country. And then COVID-19 certainly caused challenges for caused disruptions for already challenged system. And what we're finding is that local markets and municipalities are putting a pause on recycling. We see retailers putting a pause on deposit return collection. And so that there's a need to be able to find a way to pull these materials through. And at the same time, COVID, I think, is also increasing the use of plastic at this time as people see and perceive safety needs. For those of us who've been trying to support our local businesses and doing a little more takeout in these last couple months, we also see that a lot of that comes in plastic. So there doesn't seem to be any less plastic entering the system. And therefore, again, a need to be able to manage those materials, build the supply chains for recycled content. And there are really three places where recycled content comes from. So one being post-industrial, and those are things like pallet wraps and agricultural films. They tend to be a lot easier to collect. They're a little more homogeneous in material and format, typically clean and dry. And there are fewer places to collect them from. This tends to be a little bit more of a B2B supply chain. And then there's post-consumer, and this is what comes from our households, right? If you think about what you put out for recycling every week, these are a little harder to collect. There are a lot more places to collect from, a little harder to sort, not quite as homogeneous both in material and in format, and they can often be contaminated with food. And this third chain for recycled content called ocean bound is a bit of a newer category, as groups are looking to collect things from coastlines and actually potentially out of oceans, that again, to find a market for that material. So we're starting to see things in either shampoo bottles or printer cartridges, but ocean bound plastics at the moment tends to have a little bit more challenge for the food contact needs for some companies. Okay, and while I mentioned in the beginning that there isn't quite the formalized regulatory structure that we see from TSCA and FIFRA, we do see global regulatory activity on the rise. You know, and traditionally for plastics, what we have seen, so there's certainly a set of regulatory requirements around food contact and safety. And then there was also extended producer responsibility requirements in Europe and some of the provinces in Canada. And what that means is that producers or companies that sell products that are in packaging, that they essentially put in fees or taxes for based on how much material they put in the market, right? And there's different rates in different countries, but those schemes have been around for quite some time. We are starting to see frameworks in other markets, India, China, and there's discussion of that in the US as well, and I'll talk about that briefly in the next slide. But we also see other things around bans of materials. So the UN Environment and WRI put out a study maybe about a year and a half ago, found that at least 127 countries have adopted some form of legislation to regulate plastic bags. We see things around banning straws, we see banning certain materials. So we see this patchwork of regulatory requirements in different markets. I mentioned the China National Sword Policy earlier, and again, this is something that limited plastic waste imports and really sent shockwaves through the recycling markets. There's discussion of similar limitations around paper bales as well in terms of mixed paper. The EU was looking at a number of laws to strengthen the circular economy as part of the European Commission's Green Deal. And then parties to the Basel Convention on Transboundary Movement of Hazardous Waste, they are also looking about making plastic scrap or plastic waste part of that, subject to the same prior notice and consent procedure that the Basel Convention has. So there's a lot of activity happening. This is an issue that is not going to go away anytime soon. And what we see on the US side of things, increasing legislative activity at the federal level. Prior to that was last year, we saw certainly a lot of state level activity. California came pretty close to passing an extended producer responsibility legislation. We see this in Washington State proposals, and Oregon, we see some on the East Coast as well. But there's also been quite a bit of federal activity. So in 2019, there have been proposals, one called the Recycle Act, one is the Recover, and another Save Our Seas 2.0. Recycle and recover tend to be things that would appropriate funds to EPA for grants to local governments for waste management infrastructure, for consumer education. Save Our Seas tends to be a little bit more about investing in innovation and technologies, looking at commerce and DOE. There's a Save Our Seas, I think it's the 1.0, that was actually passed and signed by the administration the previous year. But if you take a look at the 2020 activity, just even in the last 2 months, you see a lot of, again, real interest on the Hill around recycling, packaging waste, things of that nature. And again, most of these are looking at appropriations, but the Break Free from Plastic Pollution Act from Senator Udall is one that actually talks a lot more, is more sweeping in its scope, and talks more about EPR on companies, the extended producer responsibility, not just some of the other things that we've talked about in the other bills. Where they will go is obviously to be determined, but there's certainly interest from legislators here. And then I'll wrap up with value chain partnership, right? So hopefully you've been able to see the flavor of the complexity of the issues. There's a lot of moving parts. There isn't really sort of a silver bullet, one size fits all solution to managing materials. And so really Mars and many other companies are involved in a number of value chain partnerships. Here's just an example of some of the ones that we've been part of. But we're looking, all of these look at what packaging design changes can companies make. What are the infrastructure changes needed to collect, to sort manage materials and then find the end markets for them. Consumer engagement. So consumers certainly, I think, have an interest in trying to make sure that, they're interested in being able to recycle what they can recycle and are interested in information that tells them how to do so. And then metrics, right? So, again, Lynn mentioned earlier about, data and on some of the other regulations. One of the things is that some of the data is quite challenging here. And then for us to be able to get good baseline data and then metrics to show progress on how we're doing against our goals as companies, as global partnerships, and again, some of these partnerships help us with all of these areas. And lastly, the value of the partnerships involves you have brands, you have retailers, you have packaging companies, you have NGOs, you have regulators, and then you also have the waste management industry, right? And so it really does, we do need all parts of the value chain to come together in order to make progress against the goals that that all companies and governments have here. And from there, I'll turn it back over to Chandler.
Well, thank you so much, Lynn and Rachel, for your excellent presentations. We will now move right into our Q&A session. So as a reminder to our participants, please enter your questions using GoTo's question box. And we do have a number of questions already, but please do send them in. I really like this first question here. I think this is a great one that really captures the intersection between both Lynn and Rachel's presentations. And we probably could spend a whole seminar on this question. But the question is, should PFAS be banned from all packaging to any detectable limit? So I will pose that both to you, Rachel, and Lynn.
Want to go for it, Rachel?
It's a great question. I think it is, certainly probably the intersection of two of these where, what is the regulatory framework for making sure packaging does the job, is safe and everything that it needs to do. And it is something that actually, while I can't really speak to it directly, I can talk to that we have our food contact materials team within our regulatory affairs who really is following that issue quite closely, and what the response would be in terms of making sure our packaging is compliant with whatever regulatory requirements that we have.
Yeah, I think that's a really good response, Rachel, because the question of whether something should be banned is, to me, a function of once a chemical substance is subject to the gauntlet of federal regulatory approvals under TSCA as a neat chemical, and given its use in food packaging or other forms of packaging under the Federal Food, Drug, and Cosmetic Act, the answer to that question is, well, allow the regulatory provisions to play out as intended. And so whether it should be or whether it is, once a chemical is subject to regulatory review, my view is let the law play out, let the applications that are under consideration be subject to the reviews that the regulations under each of the enabling statutes anticipate, and let the law and data answer that question accordingly.
Great. Well, thank you both so much. Lynn, this question I think is really directed towards you. It asks, which of the Section 5 decision types are potentially subject to judicial review once published?
Well, a Section 5 new chemical review or the issuance of a significant new use rule are all subject to judicial review. We have, in fact, under old TSCA, filed an appeal on a significant new use rule under Section 5 on the theory that the agency did not appropriately interpret TSCA Section 5 provisions as Congress and EPA rules intended. And the same holds true under new TSCA. It's a final agency action. And like anything under TSCA is very granular and a function of the administrative record that has been considered or amassed. It's probably a little more challenging under new TSCA, given the fact that conditions of use and what is considered an unreasonable risk and what is a foreseeable risk are all at play with regard to a significant new use rule. So it would be, to my knowledge, that has not yet been the subject of a judicial review determination, and it will be interesting when and if one significant new use rule is.
Great, thank you so much. And Rachel, I believe this question's really geared towards you. Is extended producer responsibility working in Canada and Europe, and do you believe it will begin to take root in the US?
Okay, so, I think there are a variety of opinions about extended producer responsibility and how well it works and its transparency. You can say, generally speaking, we recognize the responsibility for what we put on the market, and we have certainly been engaged in those systems in those markets. I think the broader picture of how do we make sure that recycling or our infrastructure actually is financed over time, that actually so it does the job, right? So to the extent that we can actually have the infrastructure that recycles, manages the materials that all companies put on the market. We are certainly engaged in some groups within, in multiple markets. So in European, in the EU, we're part of the Circular Economy Accelerator here in the US that is really taking a hard look at how, if there is EPR in the US, how would it be as effective as it can be in terms of managing those materials.
Great. Lynn, I think this one's for you. How do pre-manufacturer notice exemptions affect TSCA's ability to address potential risks arising from engineered nanoscale materials?
Well, that's a very good question. An engineered nanoscale material, as most of our participants probably appreciate, is largely considered a new chemical substance. It's a complicated question because whether or not something is new or existing is, of course, a determination of whether it's listed on the inventory. And if it's a nanoscale material that is truly a new engineered one and not listed on the TSCA inventory, or if it is on the TSCA inventory, it's not manufactured at its nanoscale, it would be considered as a new chemical substance subject to all the bells and whistles of a pre-manufacturer notice required under TSCA Section 5. And gee, for at least the last 10, 12 years, EPA has done a really, really good job of reviewing and analyzing and running new engineered nanomaterials through the predictive screening tools that EPA has at its disposal under TSCA Section 5. And in my view, the agency has done a very good job of balancing what it knows about a new material, what it has predicted using the risk methodologies that it has under its disposal under TSCA Section 5, and coming up with a robust regulatory regime that manages new nanoscale materials. So, given the passage of time, the perfection of the methods that EPA has deployed to address some of the new, novel, and sometimes unanticipated issues that new nanoscale materials invite, the regime EPA has under TSCA Section 5, both pre-Lautenberg and post-Lautenberg, have done a very, very good job of identifying potential risk and imposing risk mitigation measures through Section 5 significant new use rules and orders with respect to nanoscale materials. And I wish we had an opportunity for live audience participation, because I'm sure people may disagree with that, but I think EPA has done a really, really good job because of the nature of the program, the tools at EPA's disposal, and the evolution of its risk methods for identifying and anticipating potential risk posed by these materials and any other chemical substance that is considered new and novel for purposes of the TSCA regulation.
Rachel, I think this one's geared towards you. how might the expansion of virgin plastic production impact plastics recycling markets?
So, okay, so just make sure I understand. So in terms of the projected increase of plastic production going forward, right? Like versus, okay. So I guess it's not so much even just how much is being produced, but what we're finding, at least today, if the infrastructure stays the same, it's also about the formats, right? So we talked to if much of that material gets produced that goes into a format that's easily collectible, sortable, and has an end market, it's something that probably can get managed and be go to recycled content or into textiles or things of that nature. If we continue to put materials that right now are there's a struggle to collect and sort and recycle without changing of infrastructure, just increasing those materials means that we still have the same challenges that we have today. But I think what we find is that, companies are increasingly also looking to, again, where they have commitments around reducing the virgin plastic materials that they use, and trying to find ways to decouple business growth from virgin plastic usage. We do something similar with carbon emissions, where we look to decouple growth from carbon emissions. So something like the recycled content commitment that we have, and finding markets to continue to use that material that helps at least, again, sort of decouple that growth of business versus the growth of virgin plastic in our packaging.
Great, thank you. Lynn, this one's for you. Could you speak to how you see the new TSCA and what are some of the biggest successes and some of the biggest challenges facing the update to TSCA?
Great question, whoever asked that. And I have a couple of points as a kind of introduction to responding to that. And as many folks know who track Environmental Law Institute, you know that we did a TSCA reform 4 years later webinar back on June 24th. And we were welcome to have both Assistant Administrator Dunn and Congressman Shimkus participate in that webinar. And some of their comments in that regard, I think, are very, very noteworthy. And I urge you to download the program and listen up to all of it. But if you are listen to Alex Dunn's comments and Congressman Shimkus. And as far as I'm concerned, as a TSCA practitioner, I think there are many more successes of TSCA reform than issues where if we could do it all over again, we might have done things differently. There is no failure here because failure was not an option, right? But with regard to TSCA Section 5, new chemical review, given the enormity of the changes made by Congress, which in fact were unanticipated by people like me, because many of us thought TSCA 5 was, well, it's a successful part of the statute, right? New chemical review was going well. Under old TSCA, it was really Section 6, the review of existing chemicals, where people were really, concerned about challenges to EPA's authority. TSCA Section 4, test rules were impossibly difficult to get out. TSCA Section 8, information gathering wasn't going as well as intended. So Section 5 was thought to be running relatively successfully. And so when Lautenberg came out, and EPA had to go through an entirely different program of affirmatively determining whether or not a chemical posed an unreasonable risk, TSCA's or EPA's ability to nimbly transition to a new review program was challenging. I think EPA has largely emerged on the other side of that challenge. Chemical reviews are more predictable, more timely, and in my view, better calibrated to addressing potential risk posed by new innovative chemical technologies. But it's been a challenge. One of the areas that I will probably challenge our audience to consider is, and I don't know the answer to this question, and it may be premature to try to formulate an answer, is whether or not new TSCA has achieved the fundamental congressional goal of restoring consumer confidence in our industrial chemical program. My hope is that it has, and that as we go through existing chemical risk evaluations and as we start entering into a new phase of risk management determinations in 2021 and beyond, that consumer confidence will certainly stabilize, or in fact, we hope increase. Because from my vantage as a TSCA practitioner, the American public should have a lot of confidence in the program because it is working and it has improved significantly. And given the enormity of the task in revising TSCA in 2016 and the 8-year run up to it, I really just want to once again thank all of the Congress people who were instrumental in revising TSCA, and to EPA, thank them for their heroic efforts of implementing the law timely and as well as the agency has. It's been a huge, huge labor, and I think we are all the better for it. So TSCA Section 5, getting there. TSCA Section 6 risk evaluation and exercising EPA's new chemical data production authority under 4, chemical confidential business review. I think all of that is moving very, very well. And to the extent that there were any early challenges, I think we're on the other side of that equation with TSCA Section 5.
Great, thank you so much. This is a 2-part question, but for Rachel, I'm gonna try to combine it into one. So what do you see as some of the opportunities and challenges facing the design of sustainable packaging?
Okay, let's see, I could probably run an entire day answering that question. I think, when we look at packaging, again, thinking about whatever material choice you want to make, right? First and foremost, is it going to be fit for purpose to make sure the package actually protects the product, right? So when we think about food, there are a number of barrier properties. We need things to, have a certain amount of shelf life and make it through a distribution, the full supply chain to get to the consumer. So within that framework, we can also start to say, this is, one of the examples I mentioned, which I thought was super interesting, about just redesigning the whole format of the product itself to then, have packaging that can change into something else, into something maybe more recyclable than what they had prior to that. So, it's really thinking a little bit about what are the requirements to protect the product first, and then what materials can meet that. And then what we also do is, again, recycling is one piece of this. We're looking at, when we think about our full set of impacts, we're looking at upstream impacts from a carbon. We're looking at, obviously what it takes to produce the materials, the logistics impacts, and then finally the end of life impacts of that packaging. There isn't a silver bullet. It is really taking a look at some of the trade-offs from efficacy, from impact, from cost to consumer preference. There's a variety of things that go into those decisions, but it does make life interesting.
Lynn, this one's for you. How are biosynthetically derived substances and life forms intended to be used as a pesticide evaluated?
Well, EPA has a biopesticide division, and I know I went very quickly through the whole FIFRA program because it's very granular, as noted, very data-driven and very intense. But the agency has a very defined system for evaluating chemicals and products and ingredients that might be considered falling into that category. Whether a chemical substance is subject to EPA review or FDA review or some other review is a pretty complicated calculus and not entirely clear or transparent. We did a paper on this a number of years ago with ELI, and I would urge whoever asked that question, and perhaps we could post it after, to talk about some of the jurisdictional boundaries as between and among EPA, TSCA, EPA, FIFRA, and FDA, because what set of rules apply for jurisdictional review of chemical ingredients is often a function of the mode of action of the particular chemical at issue, what is the intended use, and what the materials are. So I didn't want to necessarily presume that it's going to be subject to FIFRA at all, because at the first instance, if it's an innovative technology, you might want to consider backing up for a minute and try to get a real good understanding of the answer to each of those criterion, because it will go into the mix of what field are we in? Are we in FFDCA? And if so, what division? Are we in EPA, FFD, or FIFRA, or EPA TSCA? And how that issue is sorted out can be a very complicated, challenging endeavor. But once it is sorted out, the collaborative effort between and among the agencies for purposes of jurisdictional review is pretty intense. And in my view, the agencies do an extraordinarily thorough job of determining what measures ought to apply and under what jurisdictional authority.
Great. Rachel, this one's for you. How important do you see partnerships in furthering the sustainability goals for folks?
So I think they're incredibly important, right? And it's not just in packaging, it's also for the ingredients that we source. What we find is that when we think about impacts and things to address all the way through the value chain, is that there isn't any one company or any one value chain actor that can really do this by themselves, right? So when we think about packaging, sort of some of the previous question that was asked to me is that the design is the one thing that is pretty much in our control, right? The waste management infrastructure and the consumer choice to recycle or not are less in our control, right? We can influence, we can communicate and things of that, give recycling instructions, but the one piece that we can truly control is design. And so therefore, since there's so much that still has to happen for materials to effectively be recycled into something new, is that we need to be working with other value chain actors. There are, anything from, again, design that maybe all brands can take a look at certain things that make it easier to recycle and then be competitive within that framework, right? And then, the advocacy piece that I mentioned with the Circular Economy Accelerator and a few other things that essentially the partnership is going to be really critical to making progress, on anything, whether it's packaging or any of the ingredients that we source to make things more sustainable.
Great. This next question, we've received this question in a form of from a couple of folks in different ways, and I think it's really meant for both of you. It's in our global economy, how are companies responding to the many variations in regulations and laws, be it packaging or chemicals?
I'll take a shot, Rachel, with your permission, because that is an issue that comes up, a lot. And we practice U.S. law in the chemical space, but our consulting firm practices international law. And so we are deeply engaged in, REACH, the European Chemical Program. We work with registering biocides and agrochemicals in Europe and South America. And so we hear from a lot of people all over the world trying to keep up with the relentless press of evolving regulatory standards pertinent to molecules, chemical substances, and how they are regulated in various use applications, whether it's in the industrial chemical space or the agrochemical space or federal food drug kind of space. And I'm also speaking in capacity as president this year and next of the Product Stewardship Society, because to me, product stewardship is a commitment to ensuring that the chemicals we use and the maintained in a way that ensures a high degree of environmental excellence and sustainability, right? So you've got regulatory standards and legal standards that are all over the map around the world. Some countries are very mature and sophisticated, others less so and evolving. And you have product stewardship standards that I think are more global and certainly more fluid, because they are not necessarily embraced or enforced by a regulatory standard from a authorizing agency or law. So at the end of the day, I think our kind of counsel is to maintain the very best product stewardship standards you possibly can. And chances are you're going to be hitting and exceeding regulatory standards that tend to be more, bottom of the ladder as opposed to top of the ladder. And if you calibrate your global operations with a view toward meeting the most rigid standard you can, you're going to be most comfortably confident that you are meeting and exceeding regulatory standards throughout the world. And most of our clients obviously don't market in a particular jurisdiction. They market a product and seek a chemical approval and then take it around the world to maximize their investment in that innovation. So trying to calibrate your product selection, raw material selection, the stewarding of that chemical, and the uses and applications to which it will be deployed in what jurisdictions, maintaining the very highest standards of sustainability and stewardship will grant you the most, I think, license to market that product in a way that is going to give you confidence that you're meeting and exceeding regulatory standards. And Rachel, I would welcome your views on that very difficult question to answer.
Sure. So I think I'll start with that Mars and every other company really strives to be in compliance with what the regulatory requirements in every market in which we operate, right? And so we operate globally, pretty much in every market. And so certainly between our regulatory affairs function as well, looks to be to manage that compliance, but also to horizon scan for upcoming regulations that are coming down the pike. So, but I like your comments around product stewardship, right? So when I started my career with Mars, I was leading sustainability for scientific and regulatory affairs. And I think, as I mentioned in the beginning, is that there's a lot of sustainability that isn't driven by regulation. So it is, is there other sort of societal expectations, this private environmental governance? I talked about retailer as regulator. Some of our retailer customers, whether it's sustainability or health and nutrition, starting to see, questions and comments and concerns from their consumers coming in the store and looking to set standards for the suppliers that they have. So there is certainly the regulatory piece, but there is this private environmental governance and the expectations and license to operate that, one can go above and beyond regulatory frameworks that do exist, but also sort of set a de facto framework based on expectations. And again, we see that we look to be, strive to be in compliance with all of those standards and in all the markets in which we operate.
Chandler, if I may, I want to just add on to a very, very important component that Rachel mentioned. And again, regulatory standards really are, I don't mean this in a pejorative sense, but they're the minimum level of compliance required, and against which one's non-compliance can be made actionable by a regulatory agency. But that private environmental governance component has driven so much of moving the needle to a more sustainable, more innovative reality, I think, over the past 15 years or so, and probably even beyond that. But calibrating your operations, selecting raw materials for purposes of chemical product production, whatever your new innovation is, it is so important not just to be mindful of what is required, even under our new TSCA law and FIFRA, which has been demanding from a risk assessment perspective for decades. But it's very important to be mindful of many other sensitivities that are driven much more by, as Rachel alluded to, the private environmental standard setting. What do NGOs think? What do other public health organizations think? You might not necessarily fall below a minimum risk standard by virtue of a regulatory standard, but if there are other issues associated with a chemical, you are not doing justice to your shareholders, stakeholders, and others by being oblivious or indifferent to those very, very important other factors that might not be enforced as a matter of law, but are super, super important. You need to look no further than methylene chloride, which some of the large retail organizations in the United States decided to ban applications of methylene chloride in paint remover products sold to consumers, even before EPA completed its methylene chloride risk evaluation. Now, I might not necessarily agree with the scientific merits of that decision, but the reality is if distributors choose to cease selling a product based on what they are hearing from their customers, that's a really important consideration that you can't be indifferent to, right? You might be able to sell your product, but if the retailers aren't going to pick it up or affirmatively preclude the marketing of a product because of concerns, even in advance of an EPA risk evaluation, that's a really important force motivator. So Rachel's point is very, very well taken, and that secondary market is every bit as influential as EPA risk evaluations, and sometimes even more so.
Rachel, did you have anything to add on that? Or?
No, I think this is, again, it's sustainability, something companies pretty much live every day. And, the commitments that we make generally aren't, from that point of view, aren't necessarily driven by regulation, maybe potentially thinking about regulation down the line, but also what makes a sustainable business? How are you an ongoing concern as a business going forward in looking at supply risk and a number of other things, but certainly your customer risk and societal license to operate really factors into that. And I would agree from, Lynn, about sort of, here's the regulatory piece that could be just the beginning of that journey, right? Here's your bare minimum, and what do you do to continue to go beyond that along that sustainability journey?
Great. So these are two separate questions that I'm going to combine. Lynn, these are directed for you. Could you remind us of the definition of pest? And then could you also speak a little bit to the recent Roundup litigation and maybe how it's affected its regulatory status?
Well, pest is pretty broadly defined, right? It is, I'm looking back at my notes here because I don't have the statute here in front of me, but a pesticide is any substance or mixture intended for preventing, destroying, repelling, or mitigating any pest. And a pest, I wish I had the to include critters, bacteria, or other types of public health vectors. It doesn't need to be a public health vector, which is a defined term under FIFRA, but it is things of that ilk, whether they're animals or insects or bacteria. The point is that they are capable of imposing a risk to human health and the environment or agricultural crops or other things that the statute authorizes EPA to regulate. And whoever asked that question, feel free to shoot me an email. We have, I'm happy to resurrect the actual statutory definition and EPA's regulatory patina on it.
And the second part of that question was, could you just speak to some of the recent Roundup litigation?
Well, there's a lot of Roundup litigation going on, both in and outside of FIFRA. The interesting case that I mentioned coming out of the Eastern District of California, I think represents a very interesting confluence of how Prop 65 labeling restrictions, First Amendment rights, determinations of what might be misbranded, and EPA or the public's right to know kind of collided. Because just last month, that Eastern District case determined that the Cal EPA OEA folks did not have the authority to compel the inclusion of the term cancer-causing on a product label for glyphosate on the theory that the agency's determination at the federal level that the term cancer-causing on the product label would be considered misbranded. And the court issued a permanent injunction against the inclusion of that term on the grounds that the Prop 65 requirement was not appropriate under the terms of that court decision. There's a lot of other glyphosate Roundup litigation ongoing with regard to just human health tort injury, whether or not glyphosate in fact causes the type of injury that plaintiffs claim. That litigation was derivative of an IARC determination that glyphosate in its neat form under certain conditions was capable of posing cancer-causing risk to humans. That's been a highly controverted decision because every other public health organization determination determined otherwise, but IARC came up with that determination and inspired a raft of product litigation, which continues to be ongoing and probably will for the foreseeable future. But in the narrow context in which we deal with these issues, it has most recently come up as a consequence of the intersection of Prop 65 labeling requirements and EPA labeling requirements under FIFRA that did not cause that type of labeling requirement. And we've done several blogs on this on our blog, our pest blog. So for more information and the citation to that very interesting California case that came out on June the 20th, please take a look there.
Great. And we have one last question, which is perfect because that's about all we have time for. This question I think really is geared towards both of you. Do either of you have any predictions for the future of product regulations for electronic products, especially consumer devices and data center equipment, and whether that's in the US or internationally?
I can briefly comment on that. I don't have insight into that, mainly because we're not a consumer electronics company, but I wish I knew the answer to that.
Well, I think from my narrow perch, there is an awful lot of intense review of some of the chemical components that go into those electronic products, right? Whether they're intended for industrial or consumer use, which I think will simply intensify as the days and years go by. The Europeans are probably a little further along given some of the RoHS type restrictions that apply. But any type of chemical component going into that type of device is subject to regulation under TSCA, and given that new chemicals or uses of chemicals will continue to be the subject of really stringent review under TSCA, you can expect to see that type of regulation increase as the days and years go by. PBTs, some metals in particular that go into such electronic equipment are considered persistent bioaccumulative and toxic chemicals. That's been subject to enhanced review under TSCA. So big picture, just, more regulation, more review, but we hope done in a way that is consistent with the very best practices of risk evaluation and risk assessment.
Great. Well, thank you so much to our participants for joining us today and for your many thoughtful questions. We hope you'll continue to think about the foundations of environmental law and especially the law and policy of products regulation. We're so grateful for your participation in ELI's annual summer school series, and we hope to welcome you all back next Tuesday for our final summer school session of 2020, where we will explore environmental justice. I want to extend a thank you to our fantastic panel. Lynn and Rachel, you both contributed so much, and thank you for lending your expertise to summer school. Thank you all so much again. Please take care and stay safe. Thank you all.
Thank you, Chandler.
Thank you.
Thanks, Rachel. Good to see you. Bye.
Bye.
Bye.